Welcome to the New Business Practicum's 15-Minute Lawyer Series, where we tell you what you need to know about the law in 15 minutes. We're joined by
Connor McNamara,
Erica Fisher.
We're going to tell you what you need to know about intellectual property in 15 minutes. Are you ready, team?
Ready.
All right, let's go.
Hi all. Our presentation today is called Protecting What's Yours, How Intellectual Property Can Help. And before we begin, I just wanted to start with a quick disclaimer. This presentation today is purely informational and does not substitute for proper legal advice. So to the extent you have questions about your own personal intellectual property needs or specific legal questions, we suggest that you reach out to us separately or find additional counsel to help you resolve some of those issues or questions you might have. And before we begin, we wanted to quickly go through the agenda. So we'll start today by giving you a brief introduction of IP and what it means to protect IP under the law, and then we'll go into the specific categories of intellectual property, including copyright, trade secrets, trademarks, patents, and finally we'll conclude by discussing how you can protect IP by contract. And we're going to begin today by talking about why it's so important to protect intellectual property. And there are three main reasons. The first one is that intellectual property law encourages artists and inventors to create and share works. The second reason is that it enables commercialization. So it gives a reason for people, it gives value and protection to business assets and encourages businesses to protect those assets. And finally, the third reason is for the public benefit and for the advancement of society. So the idea is that you want to encourage the production of art and science and technological advancement because the ultimate goal is to benefit the public who then uses those works. And as I mentioned in the beginning, intellectual property law is comprised of 5 separate areas of law that are enforced under state or federal law. Again, these are copyright, trade secrets, patents, trademarks, and contractual IP. And each type of intellectual property protection differs in terms of what is protected and how you can obtain protection. And today, I'll begin by talking about copyright. And to begin, it's important to understand what is copyright, because this is what differentiates copyright from other types of intellectual property like trademark or trade secret or patents. And so copyright particularly protects original works of authorship. And this can be very broad. It includes things like art, music, books, movies, software, architectural drawings, anything that really has some type of creative component. And in order, as I mentioned, it's really broad, and in order to understand what copyright protects, it's really important to understand what is not protected. And there are a few main limits on the scope of copyright. And one of those things is the idea-expression dichotomy. And so what this means is that copyright does not protect facts or ideas. So an example of this is if you have an idea to write a novel about star-crossed lovers, you're not necessarily going to infringe the copyright of Shakespeare if that was still under copyright. What you're really concerned about is, so that idea is not protected. What would be protected is the underlying dialogue and the specific characters, etc. And finally, as we'll discuss later on in the presentation, the fair use doctrine allows some uses of copyrighted works. And it's also important to discuss what a copyright does. So what is the point of a copyright? What does it give the owner the right to do? And with copyright, a copyright gives the owner the exclusive right to do a number of things. And that includes reproduce copies of the work, develop derivative works, distribute copies of the work, perform the work publicly, and display the work publicly. You might be wondering how you can get copyright protection. One of the coolest things about copyright, in my opinion, is that copyright protection is automatic once it's fixed in a tangible medium of expression. So that means as soon as you type a draft of a chapter of a novel or anything, as long as it's fixed in a tangible medium of expression, as soon as you record a song or write down the lyrics or compose the music, it receives copyright protection. And although copyright protection is automatic, there are benefits to registering with the U.S. Copyright Office. For example, in order to sue to enforce your copyright, you need to register, and there are certain benefits like statutory damages may be available if you are registered from the beginning. And the rationale behind this is that registering your copyright gives notice to the public that you own this copyright.
Thank you very much, Erica. My name is Connor McNamara.
I'm going to be now discussing duration of copyright protection, fair use doctrine, and then we'll move into trade secrets and eventually trademark. So protection of a copyright begins the second you create it, and it lasts for the life of the creator plus an additional 70 years. If the work was made for hire, if someone paid for that work to be created, then there are different rules in place as to how long the duration lasts. Internationally, Berne Convention countries allow simultaneous recognition. If you're going to be operating in foreign countries, you're going to want to know whether or not it is a member of the Berne Convention. Now, the fair use doctrine is an exception to copyright protections. Most frequently, it's used as a defense to a copyright infringement lawsuit. If someone is using fair use doctrine as a defense, the court is going to look at several factors to determine whether or not it truly is fair use. One of these factors that courts will look to is how transformative the use of the copyrighted material is. That's why parodies, news reporting, or teaching are all examples of copyrighted material being used in fair use context. Next, we're going to be discussing trade secrets. A trade secret is any information that provides a competitive advantage to a company so long as that information remains secret. The rationale behind this is the secretive nature of the information is what provides the advantage to the company. Once that secret is no longer secret, once it's out in the open, then that advantage no longer exists, and therefore that protection is no longer necessary. Almost anything that's commercially valuable to a business can be a trade secret. You should see a list in front of you of examples of this, but in our everyday lives, a trade secret could be something like the recipe behind Coca-Cola, or the algorithm used by Uber to link its drivers up with potential customers. So now let's talk about the requirements to actually protect a trade secret, if you were to have one. All that is required for protection is that a company make reasonable efforts to keep the information secret. Reasonable efforts are generally judged by the standards in the industry in which the company is operating. And as long as those efforts are successful, as long as the information remains a secret, that protection is in place. In the United States, we frequently use non-disclosure agreements between a company and its employees. If you're going to be operating internationally, you would want to ensure that those non-disclosure agreements are enforceable in whatever other countries you're conducting operations in. If you do that, and a trade secret is leaked, then the International Trade Commission can block imports into the US if they involve any of the information surrounding that trade secret. There are many different examples of reasonable efforts. You should see a list in front of you now, but they can generally be broken down into three main categories. The first is actual physical safeguards that you put in place, whether these are safes, locked cabinets, combinations, etc. The next are contracts with employees, whether it's non-disclosure agreements or non-compete agreements. And the final form is just limiting the information itself, limiting the number of people that have access to that information. The idea being the less people that know, the less chance the information will be leaked. Next, we're going to discuss trademarks. A trademark is something that distinguishes the good or service of one company from similar goods and services of another company. A good trademark can identify a company using either a set of words, a symbol, or even a sound. And it protects slogans, names, logos, etc. Anything that could be used to indicate the source company of a product could be a trademark. So how do you get protection? We're going to go over this in more detail in a few moments, but essentially, as soon as you use a trademark in a commercial context, you have protection under common law. However, you can register a trademark with the Trademark Commission and get more national and enforceable protection. Now we're going to discuss the duration of trademark protection. Similar to trade secrets, duration lasts as long as the trademark is maintained and protected by the holder. If operating internationally, Madrid Protocol countries enforce US trademarks without any need for an additional filing. That's why, from a business perspective, it's good to know whether or not the country in which you're operating is a member of the Madrid Protocol. The more distinguishable that a trademark is, the easier it is to protect it. In front of you, you should see a diagram giving a list of company names or trademarks. All the way to the left, under generic, you see carpet cleaning company. It's generic lettering. It describes exactly what the company is doing. Nothing distinctive about it. That is much more difficult to protect. Then, all the way to your right, under fanciful, the Kodak label. It's colorful, it's very distinguishable, it doesn't describe what Kodak actually does. That's an example of a trademark that would be very easy to enforce due to its distinctive nature. Trade dress is a type of trademark that focuses on the actual design or packaging of a product. The idea being that the design itself gives a purchaser an idea of what company made that product. A perfect example would be Maker's Mark. The bottle has a somewhat distinctive shape. It's covered with a signature red wax capping. When a consumer picks up that bottle, if they've ever encountered it before, or even seen a commercial, they'll know that that is Maker's Mark whiskey. However, trade dress cannot be functional in nature. An example of that would be a can of pop. All 12-ounce cans of pop are the same shape, same design. What distinguishes them is the trademark label placed on them, but the design themselves would not qualify as trade dress. So how do you know if something is trademarked? You simply perform an internet search. The more exhaustive your search is, the more sources you use, the easier it will be, the more confident you can be in knowing that you're dealing with something that has or has not been trademarked. If you'd like to take it further, you can hire specialized attorneys that will conduct even more exhaustive searches for you. There are two different ways to create trademark rights. The first is simply to use a trademark in a commercial context. This will give you common law protection. However, the limitations of this course of action are that you only would be protected in the geographic region in which you used the trademark commercially. For more expansive protection, you should log or register your trademark with the Trademark Commission. It will cost you about $325 to file a name and logo, but once you do, you will have national enforceable protection for that trademark. And now, you're going to be hearing from Sean Pinkney on patents.
Hi everyone, my name is Sean Pinkney, and I'll be talking to you about patent law. So, what is a patent? A patent is a unique invention or process, similar to the exclusive rights that happens in copyright and trademark law. The rights for patent holders gives the inventor, or whoever has the patent, whoever holds the patent, the exclusive right to make, use, and sell the invention, and also to exclude others from doing the same. These are really powerful rights, so it's definitely important to try and have as much paperwork involved as possible here. So there's two major types of patents. The first is a utility patent. This is probably the more stereotypical one that you might think of. For instance, this can be a machine or a process, an article of manufacture, composition of matter. It's basically a way of creating something new, its utility in that it helps produce something as a result of a process or the machine itself. The other major type of patent is called a design patent. This covers ornamental designs or the shape of items. An example here would be the shape of the Coca-Cola bottle. For instance, it's an ornamental design in that it's the shape of the bottle itself, but it's also part of the design, and Coca-Cola has a patent on this, the shape of its particular famous kind of bottle here. So there's 5 major requirements for patentability. The first hurdle, and you must reach all 5 of these in order to achieve patent protection. The first hurdle that patent holders must reach is subject matter protection. For instance, the laws of nature, physical phenomena, or abstract ideas are not eligible. There's a famous case in which an agent that existed, a chemical agent that existed in nature, but worked better when in combination with another agent that existed in nature. The combination of the two is not subject matter protected because they did exist in nature and could combine by themselves in nature. Only when the physical phenomena requires a bit of human ingenuity that would never otherwise occur in nature can be protected. The second major requirement is novelty. This kind of speaks to what I was just saying, in that there must be something new about this. It can't have already existed in the existing patent law or in other areas of commerce as well. It must be a new and unique invention. The third bar is usefulness or utility. This is a smaller bar compared to some of the other ones. Utility here just means it has some measure of use for someone. This is probably not one that will ultimately defeat the patent. The fourth requirement is non-obviousness, in that if there are 2 patents that exist together already, combining them would be not obvious to a person who is capable of having these sorts of creative juices of combining and inventive juices, that sort of thing. So if there's 2 patents that seem to make sense, anyone that could see these 2 things together could see, oh, of course I put these together, that could bar from patent protection. So there's a little bit of a bar there as well. And the last is that full disclosure is needed. This is a very important one because patent protection, as we'll get to later, exists for only a limited amount of time, and the idea is to allow future inventors to build off of existing patents in order to benefit the public, as Erica spoke about in some of the earlier rationales for intellectual property here. So you must disclose everything about the patent in very extensive filings. So how does one get a patent? So unlike copyright or trademark law or even trade secret, you absolutely have to file here. There is no common law protection for patent law. You must file with the USPTO, Patent and Trademark Office. And it's a very extensive filing process to go through. If you're working on a patent, you can file what is called a provisional patent application, which allows you to do some more minimal disclosures. After you do this, you have 1 year to file the full and more expensive patent application. In the US, the general rule is that the first to file a patent is the winner in terms of disputes amongst other potential patent holders. So you want to race to the patent office once you are ready if you are ready to file. If you don't disclose enough, the patent can be declared invalid or unenforceable. So this goes back to what I was saying with the disclosure requirement is very important, and it's one of the things that can actually undo a patent. The last thing I want to point out is that patents are very expensive and difficult to obtain. Patent attorneys are highly specialized in science or mathematics or other STEM areas. There's a special patent bar they must pass, so the legal fees for filing a patent can be substantial. $10,000 is, and again we have up here, but depending on the invention can be quite a bit more expensive. So just be prepared that there are special attorneys you want to speak to when seeking something like this. So regarding the duration and scope of a patent, it is 20 years after the filing date of the patent. That doesn't mean it will be approved by the USPTO immediately once you file, but it does retroactive to the filing date itself. However, design patents, it's only 14 years from the date of filing. So it is limited, and this again goes to allow other inventors to build upon the work that already exists. Internationally, there is a patent cooperation treaty that allows you to file simultaneously in multiple countries and jurisdictions. So if you are planning to work in other areas, this might be something you want to take advantage of as well. Lastly, we're going to talk to you about intellectual property by contract. So these are some of the fun things that can come up in terms and conditions that when you agree to use on a website and that sort of thing. So some of the things you might often see would be non-commercial use. For instance, you can't just take, if there's a free website that allows you ideas on cooking recipes and that sort of thing, you can't just take that recipe and then use it for your own commercial use. That could be a breach of contract if the terms of service say no commercial use and that sort of thing. Other things could be a license or assignment. you might not be able to use something without a license from the intellectual property holder. There are a few other things, kind of what Connor mentioned regarding trade secrets, non-disclosure agreements. Sometimes you might not be allowed to disclose what you're using on a certain website. And there's also non-compete clauses. While these are generally unenforceable in California, it might be something to take notice of if you are working outside of the state of California. One means of getting around this would be to use copyright or trade secret law instead. This allows for more unauthorized IP use. So that's our presentation. If you have any questions, the Practicum attorneys are here to help. Our contact information is on the screen, and thank you for your time today.
You wanna be starting something, you got to be starting something.